Start. If in the trial arising out of an application made under section 125, and if the husband offers to maintain his wife on condition of living with him, the magistrate may consider any of the grounds of wife on condition of live with her husband before ordering the maintenance. Under section 127 3b, the magistrate shall cancel the order the passed by him under section 125 in favor of a woman who has been divorced by or has obtained a divorce from her husband if the woman who has been divorced by her husband has received, whether before or after the date of the said order, the whole of the sum which under any customary or personal law applicable to the parties was payable on such divorce. The appellant, who is an advocate by profession, was married to the respondent in 1932. Their aunts and two daughters were born of that marriage. In 1975, the appellant drove the respondent out of the matrimonial home. In April 1978, the respondent filed a petition against the appellant under section 125 of the Code of Criminal Procedure in the Court of the Judicial Magistrate, First Class, Indore, asking for maintenance at the rate of rupees 500 per month in view of the professional income of the appellant, which was about rupees 60,000 per annum. On November 6, 1978, the appellant divorced the respondent by an irrevocable talaq and took up the defense that she had ceased to be his wife by reason of the divorce granted by him. He was therefore under no obligation to provide maintenance for her, that he had already paid maintenance for her at the rate of rupees 200 per month for about 2 years, and that he had deposited a sum of rupees 3,000 in the court by way of dower or meher during the period of idadat. August 1979, the magistrate directed the appellant to pay a princely sum of rupees 25 per month to the respondent by way of maintenance. In a revisional application slid by the respondent, the High Court of Madhya Pradesh enhanced the amount of maintenance to rupees 179.20 per month. Hence, the appeal by special leave by the husband. The view taken in the earlier 2-3 judges benches of the Supreme Court, presided over by Krishna Iyer J. and reported in 1979 to SCR 75 and 1983 SCR 1127, to the effect that section 125 of the code applies to Muslims also, and that therefore the divorced Muslim wife is entitled to apply for maintenance, was doubted by the bench consisting of Faisal Ali and Vardarajan J.J., since in their opinion the said decisions required reconsideration by a larger bench consisting of more than 3 judges, as the decisions are not only in direct contravention of the plain and unambiguous language of section 127 3b of the code, which far from overriding the Muslim law on the subject, protects and applies the same in case where a wife has been divorced by the husband and the dower specified has been paid and the period of idadat has been observed, but also militates against the fundamental concept of divorce by the husband and its consequences under the Muslim law, which has been expressly protected by Section 2 of the Muslim Personal Law Shariat Application Act 1937, an act which was not noticed in the said two decisions. Clause B of the explanation to Section 125(1) of the Code, which defines wife as including a divorced wife, contains no words of limitation to justify the expulsion of Muslim women from its scope. Wife means a wife as defined irrespective of the religion professed by her or by her husband. Therefore, a divorced Muslim woman, so long as she has not married, is a wife for the purpose of Section 125. Criminal Revision Number 199 of 1994 R was filed against the order dated 31/8/1994 passed by Shri UN Mishra, Judicial Magistrate, First Class, Ranchi, in miscellaneous case number 57 of 1985, by which he ordered petitioner husband to pay maintenance allowance under section 125 of the Code of Criminal Procedure from 11/11/1985 to 10/7/1988, date of divorce at the rate of rupees 400, rupees 400, 700 per month, amounting to rupees 12,800, and at the rate of rupees 600 per month for next 3 months idadat period, with direction that interim maintenance allowance granted earlier at the rate rupees 200 and rupees 600 respectively would be adjusted. Source is 3P Legal RHC. Exercise number is 55. Words are 746 and speed is 100.